When trusts cross boundaries. As trusts grow more sophisticated, they also grow more complex. It is now common for a single trust to hold real estate in one state, operating businesses in another, and investment accounts administered elsewhere, often with beneficiaries spread across the country. At that point, trust administration is no longer a local exercise. It becomes a multi-state undertaking governed by overlapping laws, deadlines, and fiduciary standards. This video focuses on what changes when trusts cross asset categories and state lines, and how thoughtful administration can manage that complexity with confidence. Hi, I'm Ben Vojtik. I'm partner at the Hartley Law Group. I'm licensed to practice in Texas and California. When engaged in a multi-state trust administration, you need to be conscious of multiple assets, multiple jurisdictions, and one fiduciary responsibility. Now, why multi-state administration is different? Trusts are governed by their terms, but administration is shaped by law. When assets span jurisdictions, trustees must comply not only with the trust instrument, but also with the laws tied to asset location, court jurisdiction, and beneficiary rights. Real estate is typically governed by the law of its situs. Operating businesses raise fiduciary and valuation issues under state-specified statutes. Notice, accounting, and enforcement rules may differ depending on which state's law applies. What matters most is coordination. Compliance in one state does not automatically satisfy requirements in another. The sources of complexity include asset-based jurisdictional rules, state-specific notice and accounting requirements, overlapping timelines, and enforcement mechanisms. A practical example of this is the Austin-Pasadena Trust. Consider a trust governed by Texas law and administered by a trustee in Austin. The trust owns a rental property in Pasadena, California, and an operating business in Texas. The trustee complies with Texas requirements, including responding to a beneficiary accounting request under Texas Trust Code Section 113.151. However, no California Probate Code Section 16061.7 notification by trustee is ever served. Years later, a beneficiary raises objections in California, arguing that deadlines never began to run. What appeared compliance in Texas becomes exposure in California. This is not bad faith or negligence, it is the result of multi-state complexity. The lesson here, when you have one trust in two states, there are different triggers and consequences. In this next section, let's talk about how multi-asset trusts compound the risk. Multi-state trusts often involve multiple asset classes. Each brings its own administrative demands. Real estate requires ongoing management and jurisdiction-specific compliance. Closely held businesses raise valuation governance and fiduciary duty concerns. Investment accounts introduce tax, reporting, and allocation issues. As asset categories multiply, so do fiduciary decision points, and so does exposure if those decisions are not coordinated. In trust administration, you need to be aware of different asset classes, such as real estate, operating businesses, and investment portfolios. Now let's discuss relative versus professional trustees in multi-state administration. Family members often serve as trustees with the best intentions. In single-state, low-complexity trusts, that approach can work. In multi-state, multi-asset trusts, however, the role demands legal coordination, procedural awareness, and institutional continuity. Family trustees are often forced to react to issues as they arise, engaging different advisors in different states. Professional trust administrators operate differently. They are structured to identify jurisdictional triggers early, coordinate compliance centrally, and document fiduciary decisions consistently. Now, what are structural differences? You have reactive versus proactive administration, fragmented versus unified advice, personal versus institutional continuity. Now, what is the role of multi-state legal oversight? Effective multi-state trust administration depends on unified legal oversight. A firm licensed in multiple jurisdictions can guide administration across state lines without fragmenting strategy. When court access is required in additional jurisdictions, pro hoc vice admission allows continuity of representation while complying with local procedural rules. The trust experiences one administration, not several disconnected ones. This approach reduces risk, controls cost, and reassures beneficiaries. When you have unified oversight, you have coordinated fiduciary strategy, multi-state legal capability, targeted local court access. Finally, let's discuss managing complexity with structure. Multi-state and multi-asset trusts are no longer the exception, they are the norm for sophisticated estates. With the right structure, coordination, and professional oversight, complexity can be managed calmly and effectively, protecting trustees, beneficiaries, and the long-term intent of the trust. Key takeaways: multi-state trusts require coordination. Complexity multiplies fiduciary risk. Structure and continuity matter. My name is Ben Vojtik. I hope this video has been helpful. If you want additional information, please refer to our website.